Welcome to Chapter 26, the Appeal Process. This training is presented by the Oregon Department of Education Child Nutrition Programs, ODE CNP. In this training, we will be learning about the ODE CNP Child and Adult Care Food Program, CACFP, appeal process. In this training, we will cover the definitions surrounding the appeal process, what is an appealable action, and the steps of the appeal process. Once you are done with this training, you will know what actions are appealable and gain a broad understanding of the ODE CNP appeal process. Per 7 CFR 226.6K, CACFP regulations provide specific guidance regarding those actions a state agency may take that are subject to appeal and those that are not, as well as the procedures that must be followed in providing institutions, sponsors, and responsible individuals and principals notice of their appeal rights. The Oregon Department of Education is required to develop an appeal process that adheres to regulatory requirements when a sponsor or responsible principal and individual requests a review of any action that is subject to appeal. ODE CNP's CACFP appeal procedure is available on the ODE CACFP webpage, CNP Web Packet tab, and is issued any time CNP takes an adverse action against a sponsor that is an appealable action. Before we get into the conversation of appeals, it's important to have a strong understanding of the language used within the appeal process. When a sponsor or responsible individual or principal is provided appeal rights, they are provided an opportunity for an administrative review. USDA defines an administrative review as the fair hearing provided upon request to an institution that has been given notice by the state agency of any action or proposed action that will affect their participation or reimbursement under the program in accordance with 7 CFR 226.6K. A principal or individual responsible for an institution's serious deficiency after the responsible principal or responsible individual has been given a notice of intent to disqualify them from the program, and a daycare home that has been given a notice of proposed termination for cause. Administrative reviews are also known as appeals. In Oregon, when we use the term administrative review, we are referring to program monitoring activities. An abbreviated review is limited to a review of written submissions by the appellant and may not include an in-person hearing. There are two state agency actions that, if appealed, result in an abbreviated review. First, the state agency's proposal to terminate a sponsor's agreement because of the submission of specific false information on its application, which includes the information on the application is false, the sponsor, site, or one of the principals is on the national disqualified list, or has been declared ineligible for another publicly funded program during the prior 7 years, or has been convicted of an activity in the past 7 years that indicated a lack of business integrity. Second, the accuracy of the state agency's determination to deny an application based on an institution's and/or individual being disqualified. The administrative review official is also known as the hearing official. This person must be independent and impartial. This means that although the hearing official may be an employee of the Oregon Department of Education, he or she may not have been involved in the action that is subject to appeal or have a direct personal or financial interest in the outcome of the appeal. Adverse action is an action taken by the state agency that impacts an institution's participation in the CACFP and/or their reimbursement. We will get into more specific adverse actions that are appealable soon. Now that we have discussed the basic definitions, let's talk about what adverse actions are appealable. The Oregon Department of Education must offer sponsors and responsible principals and individuals the opportunity to appeal the following actions: denial of a new institution's application for participation or participating institutions at renewal. If a new institution's application or an application renewal does not meet all requirements for the approval of applications and the execution of agreements, the state agency must deny the application and provide appeal procedures in accordance with program regulations. Denial of an application submitted by a sponsoring organization on behalf of a facility. If the state agency determines that the facility does not meet the program eligibility requirements, the state must notify the institution that the applicant is denied and provide the institution an opportunity to appeal the state agency's determination. Proposed termination of a sponsor's agreement. If a sponsor has been declared seriously deficient in its administration of the CACFP and demonstrates that it is unwilling or unable to take appropriate corrective actions, ODE-CNP must notify the sponsor that it proposes to terminate and disqualify the organization. Notice of proposed disqualification of an institution, responsible principal, and individual. In addition to notifying an institution of its proposed termination and disqualification, the state agency must notify the institution, executive director, chairman of the board of directors for nonprofits and school districts, as well as owners for for-profit organizations and any other responsible principals and individuals that the state agency proposes to disqualify them from future participation in the program. Suspension of a sponsor's participation. If the state agency has determined that the institution has engaged in unlawful acts with regard to the administration of the program, such as the submission of false information, or is operating in such a manner as to pose an imminent threat to the health and/or safety of program participants or the public, the state agency must propose to suspend the sponsor's participation, including program payments, and to propose to terminate and disqualify the sponsor and responsible principals and individuals. Denial of a sponsor's application for startup or expansion payments. If the state agency determines that an institution is not eligible to receive startup or expansion payments, or that the sponsor's request has not demonstrated that the proposed costs are reasonable or necessary, the state agency must deny the sponsor's application. Denial by the state agency of a sponsor's request for an advance payment. ODE-CNP only offers advance payments to family daycare home sponsors. Family daycare home sponsors may appeal a determination by the state agency that it's ineligible to receive advance payments or the amount of the advance payment requested is excessive. Recovery of all or part of an advance payment in excess of the claim for the applicable period through a demand for full repayment or an adjustment of subsequent payments. Family daycare home sponsors may also appeal a decision by the state agency to recover all or part of an advance if the claim covering the applicable period does not cover the advance amount, regardless of the manner by which the demand recovery is made. For example, through a demand for full repayment or an adjustment of subsequent payments. Denial of all or part of the sponsor's claim for reimbursement. ODE-CNP may deny all or part of a sponsor's claim if the state agency has reason to believe that the sponsor, or its sites, or its food service management company has engaged in unlawful acts with respect to the program operations, evidence found in audits, investigations, or other reviews provided basis for non-payment of all or part of the sponsor's claim for reimbursement. A decision by the state agency to not forward an exception request by a sponsor for payment of a late claim or a request for an upward adjustment to a claim. The denial of a claim based on a late claim submission is not subject to appeal. A decision by ODE-CNP to not forward the exception request to FNS for late claim payment or for an upward adjustment of a claim is subject to appeal. A demand by the state agency for the remittance of an overpayment. If ODE-CNP determines that the sponsor has received more money in reimbursement than what they can account for, ODE-CNP must recover the unearned funds. The demand for repayment is subject to appeal. If the sponsor believes that the repayment demand has not been calculated correctly, they must provide documentation for this to the hearing official for review. Any other action to the state agency affecting a sponsor's participation or its claim for reimbursement, except as noted in program regulations. ODE-CNP may take other actions affecting a sponsor's participation or its claim. For example, limitations imposed on the number of sites a sponsor may have, or determinations regarding whether specific costs included in the sponsor's budget represent allowable program expenses. Now that we know what actions are appealable, let's talk about what actions are not appealable. The following actions are not subject to an appeal, and ODE-CNP is prohibited from offering appeals for any of the following actions. A decision by FNS to deny an exception request by a sponsor for payment of a late claim or for an upward adjustment to a claim is not subject to appeal. A determination that an institution is seriously deficient. Disqualification and placement on the state agency list and the National Disqualified List, also known as the NDL. Note, while sponsors and responsible principals and individuals must be given the opportunity to appeal the state agency's proposal to disqualify them, the resulting disqualification and placement on the state's list and the NDL is not subject to appeal. Termination of a participating sponsors agreement, including termination of a participating sponsors agreement based on the disqualification of the institution by another state agency or FNS. The termination of a sponsors agreement is not subject to appeal because the sponsor is afforded the opportunity to appeal to a different state agency's proposal to terminate the sponsors agreement. A determination by either the state agency or FNS that the corrective action taken by a sponsor or a responsible principal and/or individual is not adequate to warrant the removal of a sponsor or the responsible principal and/or individuals from the national disqualified list is not subject to appeal. While a state agency must consider the request, a determination that a previously disqualified sponsor or its responsible principal and/or individual has failed to provide sufficient information to support recommendation to remove them from the NDL is not subject to appeal. If the state agency agrees to submit the request to FNS regional office for consideration, a decision by FNS that removal from the NDL is not warranted is not subject to appeal. When an action is appealable, there are certain steps that the Oregon Department of Education must take to notify organizations and individuals. Additionally, the sponsor and responsible principals and individuals must take certain steps to appeal an action. When an adverse action is taken against a sponsor, the state agency must notify the authorized representative, board of directors for nonprofits and school districts, all owners of a for-profit, and other identified responsible principals and individuals that includes the action that is being taken or proposed. Notice means to be sent by certified mail, return receipt, by fax, or by an email that describes an action proposed or taken by the state agency regarding a sponsor's responsible principals and individuals' program participation. In the notice, the state agency must include the basis for action and the procedure under which the institution or responsible principals and individuals may request an appeal of the action. An appeal request must be requested in writing by a sponsor and/or its responsible principals or individuals no later than 15 days after the date the state agency's notice of action is received. An in-person hearing must be held in addition to or in lieu of a review of the written documentation only if the written request for appeal specifically requests an in-person hearing. Appellants may be represented by legal counsel or another person. State agency staff must be allowed to observe the hearing. Upon receipt of receiving a request for a hearing, the hearing official will acknowledge the request within 10 days. Information upon which the state agency based its actions must be available to the appellant for inspection. The request must go through the hearing official to review the documents. Appellants may refute the findings in the notice of action either in person or in writing. Hearing officials will not consider written documentation received more than 30 days after the date the appellant received the notice of action. The submitted written documentation must clearly identify the appealed action. The following slide shows a timeline of the appeal hearing process. Notice of action is received by the sponsor and the responsible principals and individuals affected. The sponsor has 15 days to request an appeal in writing. If an in-person hearing is wanted, it must be requested in the written request. Within 10 days of ODE CNP's receipt of the request for appeal hearing, ODE CNP's hearing official responds. For the appellant to refute the findings, all supporting documentation must be received by the hearing official within 30 days of the notice of action receipt by the sponsor. The documents must clearly identify the appealable action. Once the hearing begins, no further documentation will be accepted. The hearing must be held within 45 days of the date of the receipt of the request for appeal, but not before the appellant's written documentation is received. If the hearing is in person, advance notice of the time and place of the hearing will be provided 10 days prior. After the hearing is complete, the hearing official determination will be made within 60 days of receipt of the appellant's request for an appeal. The review official's determination is the final administrative determination granted to the appellant. It is time for a knowledge check. A sponsor has blank days to submit an appeal from the receipt of the notice of action? A, 5, B, 10, C, 15, D, 30. The answer is C. 15 days is the number of days a sponsor must submit a request for an appeal from the receipt of the notice of action. This training covered the definition of terms used in the appeal process, the federal regulations, what is appealable, and the steps of the appeal process. ODE supports equity and excellence for every learner. This institution is an equal opportunity provider. Thank you for taking this training.